Welcome to the Wall Street world of high finance, mergers, and acquisitions of businesses here in North America and worldwide. Meet two of Wall Street's most successful private equity investors, Neil Cohen and Darren Mackenzie Jaffe. Since 1994, they have successfully been involved in many significant mergers and acquisitions of companies that all require detailed financial and legal analysis. Having completed numerous turnarounds of businesses with operations in North America and Europe, they are proven specialists in the acquisition and restructuring of distressed companies. They are experts at what they do. In 2012, Neil and Darren retained Michigan-based law firm Jaffe Raitt, Heuer & Weiss PC for legal advice for the purchase of a manufacturing company called LSI Corporation of America, Inc., for the pair's holding company SSL Assets, LLC. Jeffrey Weiss, one of the firm's partners, was the lead attorney in this matter for Jaffe. Neil and Darren wanted to get the absolute assurance from Jaffe that they would not be held personally liable for any issues relevant to the company's unfunded pension liability tied to the acquisition. Based on their long, successful business experience, Neil and Darren know that these complex business transactions need legal expertise from law firms to ensure that all due diligence on any pending financial investments are fully disclosed and vetted. It's a mandatory prerequisite. But as a federal court jury concluded in 2017, Jaffe's and Jeffrey Weiss's advice were absolutely wrong because the Jaffe lawyers failed to perform the necessary pension liability analysis. And as a result of the acquisition, Neil and Darren's company, SSL Assets, became obligated to pay LSI's pension liability when LSI ceased operations. The jury concluded that Jaffe breached its duty of care in providing legal advice and awarded a $5 million verdict against Jaffe Raitt, Heuer & Weiss PC for legal malpractice for failing to properly vet a client's pension liability prior to an acquisition. In this new insider exclusive Justice in America network TV special, Bombshell, $5 million verdict for legal malpractice against Jaffe Raitt, Heuer & Weiss Law, and why their legal advice was so bad. Our news team is on location with Jeffrey Golder, partner Stinson Leonard Street LLP in Phoenix, Arizona, to get the complete story of how he successfully represented Neil Cohen and Darren Mackenzie Jaffe and the current status of the case. This is the Insider Exclusive, live from Arizona.
It is my great pleasure to introduce Jeff Golder to the show. Welcome to the show, Jeff.
Thank you, Steve. Good to be here.
We're here in Phoenix today covering a case that you represent some high finance Wall Street types that are in the business of acquiring companies where they see value and turning them around.
My law firm, Stinson Leonard Street, is a firm of about 450 lawyers. Yeah. We are a business law firm. This is the sort of work that we do, yes.
Because it falls under the area which you, I think, are the head of professional liability, right?
That's right. We have a practice group called the Professional Liability Practice Group, and I'm the head of that group.
Yeah, and under that group and in that group, you represent professionals like accountants, you represent lawyers, and anybody else that really has a kind of a license, right? And when they're sued, and also when a company who hired somebody, let's say, that didn't do the best job possible, you end up suing them too, right?
That's right. So we're handled both sides. Sometimes we defend the professionals, sometimes we sue the professionals.
Okay. Tell us about your clients in this particular case. Who are they?
In this case, there were two principals, a gentleman named Neil Cohen and his colleague Darren Jaffe. Their business is finding undervalued companies, buying them, improving their operations, and then ultimately selling them.
It's a lot when I first read this, like Berkshire Hathaway in a way, where they recognize value, they see how they might be able to maybe possibly acquire them or run them a little bit better, correct?
That's their concept.
And from my understanding, your clients have a long history of doing this. I think 20-some years, right, of doing this? 1994. Right?
Yes, I believe that's true, and they've been very successful, although this particular transaction obviously did not work out the way they'd hoped it would.
And this was done on a separate company that they were part of, SSL Industries, correct?
The company that they bought was called LSI.
Right.
It was a company based in Minneapolis, and it made bookcases and shelving and things of that nature.
Right.
The company that you mentioned, SSL Assets, is a company that was ultimately saddled with the obligations, the pension fund obligations of LSI.
So what happened? You know, they're experienced. They hired a law firm to determine if there was any potential liabilities, right? And there was one, wasn't there?
So they, of course, do due diligence when they look at a company. In this instance, they looked at purchasing LSI. They learned that LSI had what's called an unfunded pension obligation.
To give an idea to our audience, when you say an unfunded pension plan, it means there wasn't enough money to pay all the pensions, right?
That's right. In this case, without getting too deeply into the weeds, this was called a multi-employer pension plan, meaning it was a small company, not like a General Motors, for example, that sponsors its own pension plan. Multi-employer plans are several small companies will get together, pool their assets, and they do it to keep their administrative expenses down.
Right.
The risk is if a company that is a part of this multi-employer plan goes out of business, then it gets sued by the pension fund administrator, and potentially the people that bought the company, the people that are principals of the company, are exposed, and any other companies that they're associated with.
I'm just kind of curious, when these companies joined together to be part of this multi-pension plan, how do the individual members of this group know how well the companies are faring over a period of time?
There is a pension fund administrator, and they give periodic reporting of whether there's sufficient funds in the pooled account to meet the pension obligations.
So in the company that Neil and Darren wanted to buy, there was a liability for the pension plan.
That's correct.
And they wanted to buy the company, but they didn't want to be exposed or be personally liable, right, for this pension plan.
And you're correct. And that was the very first thing that they communicated to the law firm that they ended up having to sue, which is the Jaffe Raitt law firm.
This kind of sums up where they told Neil and Darren the incorrect advice, right?
You're correct. This was a little bit of a different trial in the sense that nobody disputed that the advice the law firm gave was wrong.
Including Jaffe.
The issue for this controlled, it's a concept called controlled group liability. In other words, if other companies that the same individuals own might be held liable, it's a mathematical computation. And so in this case, the lawyer for the Jaffe firm came to, he says he came to Cohen and Chafee and asked the question, did they own any companies in common? Now, Cohen and Chafee say they never had that conversation,
Right.
But let's assume that they did. All he said was, do you own any companies in common? He never explained what that meant. Under the very arcane rules that apply to pension funds, he needed to explain a lot more for them to be able to give an intelligent and correct answer to that question. It was like, for example, Steve, if you go to a doctor and you don't feel well,
Right.
and you say to the doctor, I'm having a problem with my head or my stomach or whatever. And the doctor says, tell me everything I need to know about you in order to properly diagnose you.
Mhm.
Of course, that's not the way it works. The doctor knows what the problems might be. And so the doctor asks you questions so that they can properly diagnose. The same thing applies here. The Jaffe law firm never asked the right questions. The clients didn't know the correct information to give. That was where the problem arose.
And what happened at the trial?
Well, so we took the case to trial,
Yes.
tried to settle the case, couldn't get it settled. We tried the case in federal court in downtown Detroit, Michigan. It took about a week and a half, and the jury returned a verdict in favor of their company SSL assets for every penny that the company had sued for, and it awarded Mr. Cohen and Mr. Jaffe about $1.7 million in personal damages.
Okay, so the total legal malpractice verdict was $5 million.
That's right.
Okay. The attorneys that represented Jaffe, did they represent themselves, by the way?
No, they had an outside law
Okay,
firm.
the attorneys that represented them, what was their defense? What did they keep harping on that the jury did not believe?
They had three defenses. First of all, they said, yes, the advice the law firm gave was wrong, but it wasn't the law firm's fault. It was the client's fault.
Okay, so in other words, they're saying the client should have told them information that the client didn't know that they should tell them.
That's correct.
Getting back to your analogy about the patient coming in to see the doctor.
Right. And in fact, in this case, the primary contact at the Jaffe firm was a gentleman named Jaffe Weiss.
And he's one of the named partners.
No, same last name, but he is not the named partner.
Okay.
They're not related.
Okay.
But in any event, Weiss is not a pension lawyer. They had a pension lawyer within the firm, but she was not the point of contact with the clients. And so Weiss didn't know the tests that applied. Weiss didn't know the questions to ask.
Right.
And of course, the clients didn't know what information should be volunteered.
Right. It's like me bringing my car into a mechanic. And I said, hey, there's a lot of smoke coming out the back, and the exhaust pipes and the car's, stopping and stalling and stuff like that. And I go to a mechanic who doesn't know what he's doing, right? He doesn't ask me anymore. He doesn't know what he's doing. He gives me a couple of spark plugs. I drive down the street and the car blows up. Same thing, right?
That's right.
In other words, they came to an outfit, a law firm, Jaffe, that they expected would know the right things to look for and give the proper advice, right?
Well, yes, and in fact, they came to the Jaffe firm because the Jaffe firm put itself out as a specialist in union issues and union pension issues.
Yeah. What you bring up an interesting, and we talked about a point. We talked about this before the show. Union, the word union. What is the difference between a small firm pension fund that is unfunded and a union pension fund that is unfunded?
Well, in the union context, I mean, there is an administrator of the plan, and it is controlled by federal statute, which is referred to commonly as ERISA.
Okay.
And the ERISA rules are, if a company that is a part of these multi-employer plans ultimately goes out of business, stops making the contributions that it's required to make, then the plan administrator is by statute required to pursue that company for the default and any other companies that might be associated in some respect.
Right. Thereby holding someone personally liable, correct?
That's correct. And that is exactly the concern that Mr. Cohen and Mr. Jaffe had here. That's why they went to the firm. They told them that was their focus. Yeah. The law firm knew it was the focus, and they gave them the wrong advice.
Now, with this $5 million verdict, you would think that, okay, they have to pay. Jaffe's legal malpractice insurer has to pay. But they have appealed the case, haven't they?
The case is currently on appeal at the Sixth Circuit Court of Appeals.
Okay. And they've appealed it for your guess?
Well, the basis of the appeal is, and you had asked me a moment ago what their defenses were. One of their defenses was they say that they didn't have an attorney-client relationship with the SSL Assets company, the company that ultimately got saddled with this obligation.
The attorney that they were working with at Jaffe, he knew about SSL, did he not?
That was their defense. He said he did not know about SSL. Okay. Their defense is no one ever mentioned the existence of SSL to the law firm. Okay. Our response to that is we didn't know the tests that applied because the law firm never explained it. We would have been happy to tell them about SSL and any other company that Mr. Cohen and Mr. Jaffe were involved in that could possibly have exposure.
Right. And Neil and Darren were the clients of Jaffe, technically, attorney-client, right?
There were three clients, Mr. Cohen, Mr. Jaffe, and SSL Assets. That's what the jury found. Okay. That's not what the law firm argued, however.
Right. So they are appealing it, and it has to go through that route. waiting for when is a trial next year or something?
Well, it's not a trial. There will be briefing and there will be a oral argument before a panel of federal court appeals judges, and that'll probably happen next spring.
In these kinds of cases, what does that teach professionals out there?
Well, in this case, because the main issue being appealed is whether there was an attorney-client relationship between the law firm and the client, it teaches the lawyers to be careful and to define for the client who the law firm considers the client to be. In this case, for example, and it is typically the case, law firm policy is when you have a new client, you do an engagement letter. An engagement letter is the contract between the lawyer and client. It identifies what the engagement's all about. It identifies who the client is. Jaffe had that sort of internal requirement, but Mr. Weiss just failed to do it.
And what does he have to say about that, by the way?
He doesn't have anything to say about it.
I watched some of the video depositions, and I remember when you were deposing him.
Yes, that's right.
When you were deposing him, you were asking him questions, and it took him an awfully long time to answer a question agreeing with what you just said.
Well, and that was typical of Mr. Weiss, who would he would stop and think and wait and think some more before answering even the most basic questions. And we played those video clips to the jury, and I think it had an impact.
How damaging is this kind of a case to a law firm?
I think this type of case is extraordinarily damaging to a law firm for a couple of reasons. Of course, it's damaging to any law firm anytime it makes a mistake.
Right.
But in this instance, the way the law firm reacted to the mistake is the most damaging aspect of all.
By blaming the customer, the client.
By blaming the client and by disputing that there even was an attorney-client relationship.
I found that unbelievable.
So it is mind-boggling, and in fact, it is, I think, something that should be concerning to any client of that Jaffe Weiss law firm. The firm didn't stand behind its work here. In fact, it blamed its client and denied that they ever even had an attorney-client relationship, despite the fact that they were paid $75,000 for the work.
Well, I'm certain that they don't want the rest of the world to know this.
Well, they had an opportunity to settle the case, and they didn't.
Let's talk about professional liability and legal malpractice. What exactly is legal malpractice? You have a lot of people say, my lawyer didn't represent me well. What is the definition of legitimate legal malpractice?
There is a concept out there, and it is called the standard of care. And the standard of care means what a reasonable lawyer would do under similar circumstances. Doctors have a standard of care. Other professionals have standards of care. It doesn't mean that the lawyer is a guarantor of the success of the business transaction. It simply means that the lawyer needs to do what a reasonable lawyer in these circumstances would have done.
Your law firm is a very large law firm, lots of lawyers. You get lots of people call you and say, hey, would you represent us in this particular case? What is it you look for personally when somebody comes to you with a case where they believe that the professional that was representing them has not lived up to the standard of care they were supposed to, or a professional is being accused by someone for something that he's really not responsible for? What do you look for in a case?
Well, and in fact, we do both types of work. We don't just sue the professionals, we defend the professionals as well. So what we do, of course, first of all, we make sure that the client knows who the law firm considers the client to be. That's something Jaffe failed to do here. That's the first step. Then when we get into the gist of it, we have to make sure that we are getting the right information from the client. If I don't know the particular subject matter of the transaction, then I involve another lawyer in the firm who does, so that we're sure that we're asking the right questions of the client. Then when we have accumulated all the necessary facts, before a lawsuit is ever filed, I go to someone else who is an expert in that industry, lawyer, construction, architect, engineer. I go to someone in that industry and I say, this is what happened. do you believe that this person fell below the standard of care, below the reasonable conduct of someone in that business?
Double check things.
That's correct.
Any other parting words regarding this case?
The most important point, I think, is the Jaffe law firm not only gave the wrong advice, they then blamed their client for their own wrong advice, and they failed to even identify to the client who the law firm felt the client was. I think any client of the Jaffe Raitt law firm should be seriously concerned about the way the firm has reacted in this case, because they didn't stand behind their work.
Well, I'm glad you're bringing this out to the public, and I want to thank you for spending time with us. Thank you.
Thank you, Steve. We appreciate it.
Thanks for joining us. You can get more information about our guest and the issues at insiderexclusive.com.